Regulation of the head of the National Police of the Republic of Indonesia. Number 6 of 2019. About criminal investigation. How to call witnesses and suspects in criminal investigation process. Article 17. The summons as intended in Article 16 letter A, is made in writing by issuing a summons on the basis of a police report and an investigation warrant. Summonses to suspects/witnesses/experts are carried out in accordance with the provisions of the laws and regulations. Summonses to suspects/witnesses/experts are made through representative of the Republic of Indonesia where the domicile of the summoned person, for Indonesian citizens located outside the territory of Indonesia, or representatives of their country in Indonesia, for foreigners who are outside the territory of Indonesia. Summons as intended in paragraph 3, coordinated with the Division of International Relations. Police. Summonses to state officials are carried out in accordance with the provisions of laws and regulations. The suspect, who has been summoned for questioning for investigation and is not clear of his whereabouts, is recorded on the People's Search List and made a person search warrant. Article 17 of the Regulation of the Chief of Police of the Republic of Indonesia Number 6 of 2019 Paragraph 1 and Paragraph 2 above regulates how a citizen of the Republic of Indonesia, who will be questioned regarding a criminal report, that is, police investigators are required to issue a summons in writing on paper. So, not by way of being called as delicious as possible, for example through messages sent via other civilians, via SMS, or via WhatsApp. The appearance of the summons letter was caused because there had been an LP or police report and an investigation warrant. In the letter of calling there is written the name of the person who will be asked to be accompanied by what day and what date of the month is it related to what time of day or date to attend the summoning with the receipt of his letter in the hands of the person who will be called at least there is a distance 3 days before the time the requested person came to the police investigator's office. As a criticism of paragraph 6 of Article 17 of the Police Chief Regulation Number 6 of 2019, which states that suspects who have been called for examination for investigation of cases and are not clear of their whereabouts are recorded in the People's Search List. From the editorial admin proposed that paragraph 6 of this admin's really hopes that in the future the leaders of policy makers in making instructions for the implementation of this criminal investigation process can further clarify the limits and scope of what kind of circumstances and to what extent is intended by the sentence it is not clear its existence. Why is this important? Karena understandably there are many definitions of a rule that is quite clear still always open weak point space to be misused. Is it again against an redaction of the provisions of laws and regulations whose sentences are less clear the limits of the limits? If it is left then it will further add to the increasing further adverse effects. It will always appear that will eventually interfere with the investigation and investigation process that hurts the sense of justice for whistleblowers, victims, and indigenous peoples. Slowly and surely it will degrade law enforcement achievement and become a sign of a failure. Admin. Indonesian Children's Institute. Forum for the Study of Business Rights, HGU. Advocacy of Arable Land Rights versus Certificate of Right to Use, HGU. Email. loskaRtianameraputai@gmail.com